Welcome to the Consumer Financial Protection Bureau's field hearing on consumer debt collection. The Consumer Financial Protection Bureau is an independent federal agency whose mission is to help consumer finance markets work by making rules more effective, by consistently and fairly enforcing those rules, and by empowering consumers to take more control over their economic lives. My name is Zixta Martinez. I'm the Acting Associate Director for External Affairs. Today's field hearing is being live-streamed at consumerfinance.gov, and you can follow CFPB on Twitter at CFPB to learn more about what the Bureau is doing. We'll begin today's field hearing with remarks from some well-known Washington State luminaries. Then you'll hear from CFPB's Director Richard Cordray. This will be followed by a panel discussion on consumer debt collection that will be led by the CFPB's Deputy Director Raj Date. After the panel discussion, audience members will have an opportunity to tell us their stories. So let's get started. Our first speaker is Mayor Michael McGuinn. Mayor McGuinn is the 52nd mayor of Seattle. Since taking office, he has been an ardent supporter of those in need and consumer protections. He has passed legislation to cap and curb predatory towing fees, to ensure mandatory inspection of rental housing to protect renters, and he is currently investigating what can be done locally to limit predatory lending. Under his administration, Seattle is a founding member of the Cities for Financial Empowerment Coalition. Please join me in welcoming Mayor McGuinn.
This is great. Zixta's used up most of my talking points, so that'll move things along more quickly. First of all, I am really grateful to welcome the CFPB Director, Richard Cordray, and his team to Seattle. And for folks here, I always make it a point to welcome agency heads from the Obama administration at a time when the financial markets had completely collapsed, a time when we were looking at huge unemployment in this city, a lot of distress and financial need. Private capital markets were not lending. Private construction was at a standstill. A lot of our resources for any new initiatives, and our own budget had been hammered, of course, by the decline in the economy. So much of our money for new initiatives came from the federal government and their investment, the stimulus, which has gotten a bad name, but I'll tell you, it's helped us out here. We're able to work on local roads. We started our Community Power Works program, in which we're doing energy efficiency retrofits for homes, multifamily, commercial buildings, and we've managed to put together community workforce agreements for that work so that the people who most in need of work and being connected to the workforce can get connected. And I can go on, but it's a number of things where it was the ray of hope on investment. So I welcome any member, any head of the Obama administration here, and just as an appreciation. And, you know, if you got any more of that to send our way, you know, let us know. I also want to acknowledge Congressman McDermott, who's just been an incredible champion of Seattle in Washington, D.C., and played a role in that. And, you know, we have a seawall project coming up, and we appreciate Congressman McDermott's help on that as well. We have to work with the U.S. Army Corps of Engineers to make that work well. This is especially poignant coming here for this hearing on debt collection and the mission of CFPB. I just came from our Regional Committee to End Homelessness, which is a very ambitious title of the committee with an extraordinarily challenging goal. And what we know is that the needs for shelter have risen in the past few years, despite deeper investments in the creation of new housing. We've successfully created more housing for very low-income people to move people out of shelter into housing, but we have not been able to reduce the demand for shelter. So we're looking at how do we take people who are in desperate straits and lift them up and out, and the Consumer Financial Protection Bureau is on the other side. How do we educate people? How do we support people? How do we protect people from predatory practices and keep people in their homes and keep people in a position to take care of themselves and their families if they have one? So we've looked at that role too. Zixta graciously mentioned some of the things we've done: predatory towing fees, rental housing inspection. Right now, if you have a bad rental housing and you call to complain, you're going to worry about retribution. We're going to inspect all of the rental housing in the city over a period of time, random inspections and mandatory inspections to lift up the quality of housing across the city. We've passed paid sick leave legislation as well, so that there's a minimum floor. We're going to take a look into predatory lending practices, see what we can do locally. We've also had a tremendous partnership with professionals in the city of Seattle who've stepped forward. We do financial empowerment seminars and conferences, and we've gotten professionals in the financial planning fields. You know, we could get 50 of them at a time. They'll come up to North Seattle Community College. They'll be there all day, and people can come on in and get help. This library right here, during tax season, they have accountants will be upstairs here, and they will give help to anybody who comes in with their tax forms. So we know how critical it is that people have information, have the tools, have the support to make smart financial choices for the future. And we also know how critical it is, the role that government plays in holding financial institutions accountable and holding ourselves accountable as a community to the ideals we have about giving people opportunity. So again, I'm very grateful to welcome CFPB and Director Cordray here. Thank you.
Thank you, Mayor McGuinn. Our next speaker is Congressman Jim McDermott. Congressman Jim McDermott, who represents Washington's 7th District and most of Seattle, has been a steadfast advocate for consumer protection and serves as the ranking member of the Ways and Means Subcommittee on Trade. We thank him for being with us here today. Congressman McDermott.
Good morning. We welcome you, Mr. Cordray, to a typical Seattle day. It's good to be inside right now, but the sun will come out a little later in the day. When I went to Congress 25 years ago, I was on the banking committee. The chairman was Henry Gonzalez, and we went through hearing after hearing after hearing about the savings and loan mess. So I've been looking at this issue of consumer protection for a very long time. Chairman Gonzalez wanted to have what we now have with the CFPB. He wanted it then, but nobody would listen. It took the collapse of 2007 for the Congress finally to pay attention and put this in place. And Henry realized that lots of people receive things and are offered things, and they don't have the intellectual or the background educationally or whatever to understand what's being put in front of them, and they buy, and they need somebody to protect them. The free enterprise system is very simple, according to anybody who looks at it. Make money any way you can. And the government has a very important role, and that is protecting the public from the excesses of the free enterprise system. It's very simple. And this agency has been essential for 25 years. We have not had a functioning one. We saw the resistance to it when Elizabeth Warren was proposed as the nominee and the Congress went up in arms and, we can't have this stuff going on. And when she stepped down, Richard Cordray was willing to step up and take the job. It is not an easy job. It is a tough job because you've got to stand against the whole free enterprise system and say, hey, look, you can make money. It's all right. But let's be fair and let's be honest and transparent in what we're doing. Now, the agency has already had 3 successes against credit card companies. Living in Washington, D.C. and opening my mail, every day I get an offer from some bank wants me to have a credit card, and it's got some wonderful glowing offer that if I would just jump for it, I would be the richest man in the neighborhood. Well, the fact is that it isn't true, and it hasn't been true, and this Bureau has brought them to ground. It should be a message to the banking industry in this country to be transparent and honest and stick to banking, not trying to make as much money as you can off people's inability to understand exactly what's happening. So I'm pleased that you're bringing this hearing to Seattle. I did find out in talking with him a little earlier, really why he's here. On his wedding, he came on his honeymoon trip to Seattle. So welcome back. Thank you.
Thank you, Congressman McDermott. Next is the Consumer Financial Protection Bureau's Richard Cordray. Richard Cordray is the CFPB's first director. Director Cordray.
Thank you, Zixta. And that's true what the Congressman said. On our honeymoon, my wife and I started in San Francisco and drove up the coast to Seattle, and then she had the difficult experience of moving back with me to Ohio. So thank you for being here with us in Seattle for this field hearing. I would also like to thank our colleagues from the Federal Trade Commission for joining us today. Over this past year, we've come to realize we could not have a better group of partners than they have been to us, standing shoulder to shoulder to protect consumers across this country, and we enjoy every chance to fight alongside them on behalf of each of you. I found when I came into the world that I was lucky in life because I already had a brother on the scene to work with me, to help me, and to look out for me, and the Federal Trade Commission has been that to the Consumer Financial Protection Bureau. We're here today to talk about debt collection. Because of my background in state and local government, it turns out that I've been immersed in this topic for a long time. I started out as a county tax collector, making a point to apply myself to collect tens of millions of dollars in property taxes, back taxes that had gone unpaid in some instances for many years. It seemed to me grossly unfair to all the law-abiding taxpayers who somehow managed to scrounge up their payments on time to know that others were shirking their obligations and getting away with it. We did not have any sophisticated methods, so we just applied elbow grease and shoe leather and as much ingenuity as we could muster. We reported scofflaw businesses to the Better Business Bureau, and if that did not work, to the Dun & Bradstreet Credit Rating Agency, and if that did not work, to the local banks. We pursued them in court, including the bankruptcy courts, and we gradually moved ourselves up their priority list to get paid what we were owed. But out of that work, I also learned some very different and unexpected lessons. I came face to face with people who were in trouble, individuals, many through no fault of their own, victims of disease, divorce, death in the family, dislocation from job loss. My team and I called and visited seniors who had never fallen behind on their taxes before, whose delinquency was a red flag and a cry for help. We put people on payment plans to give them a chance to dig out of trouble. Out of these experiences, I first sought to grasp the foreclosure crisis, and I became convinced of the urgent need for greater financial know-how and financial capability for every citizen. Later, I served as Ohio Attorney General, where I found myself on both sides of the equation in debt collection. On the one hand, I was the primary debt collector for the state government, marshaling an army that collected hundreds of millions of dollars in unpaid fees, taxes, fines, and penalties each year. On the other hand, I was charged with enforcing the law against every debt collector, big and small, who was operating in the state. I know firsthand how hard this work can be. But I also know that it can be done the right way. And I came to understand how hard it is on people when it is done the wrong way. As we continue to emerge from the devastating financial crisis of 2007 to 2008, we now find that debt collection is a central issue of our times. Currently, about 30 million consumers, almost 1 out of every 10 Americans, are being pursued by debt collectors for amounts that average about $1,500 apiece. Independent debt collectors are in the business of collecting debts for others, and they conduct 3 main types of activities. First, they collect defaulted debt owned by a creditor in return for a fee. Second, they may buy debt in default and collect the proceeds for themselves. Third, they may specialize in collecting debts through litigation, and they may engage in any or all of these activities. We know that debt collectors represent a wide spectrum of firms. Many play by the rules and are simply doing their jobs, trying to collect what is legally owed. Indeed, the work they do is integral to the proper functioning of the consumer credit market. But others cut corners and seek to gain an advantage by ignoring the rules. Our job, and that of our partners at the FTC and elsewhere, is to root out those bad actors. Not only do they hurt consumers, but they're also a detriment to every debt collector who is faithfully following the law. In fact, a stated purpose for the Fair Debt Collection Practices Act is that Congress wanted to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged. At the Consumer Bureau, we deeply believe that reasonable market oversight is critical to fostering fair competition in consumer financial markets. We will be using both our supervision authority and our enforcement authority to oversee the market and go after bad actors who flout the law. What is supervision authority? It is the authority to send a team of examiners to scrutinize a company's business practices and determine whether they're in accordance with the law. This broad authority is an effective tool, a preventive tool, to prevent and correct any violations that are occurring and to find ways to resolve matters that are causing harm to consumers. The Bureau is already supervising the debt collection practices of many large banks and non-bank lenders to make sure they are complying with federal consumer financial law. Now we're taking another step forward to protect consumers against violations of the debt collection laws. The Consumer Bureau is announcing today that we will be expanding our supervision program to cover the larger firms that principally collect defaulted debts on behalf of creditors. We will be monitoring these debt collectors just as we've been monitoring the large banks and non-bank lenders. Beginning in January, any firm that has more than $10 million in annual receipts from consumer debt collection activities will be subject to our supervisory authority. This authority will extend to about 175 debt collectors, which account for over 60% of the industry's annual receipts in the American consumer debt collection market. This new federal authority will enable us both to protect consumers and to support law-abiding debt collectors more effectively. We're also releasing examination procedures in the field guide that our examiners will use to assess whether creditors and debt collection firms are following the law. Through our ability to conduct on-site examinations, the Consumer Bureau will be in a position to evaluate whether federal consumer laws are being followed at every stage of the process, from credit origination to debt collection. We will continue to exercise enforcement authority across the market to address problems after they surface, but our supervisory authority will mean we can identify these problems and root them out at an earlier stage in order to minimize harm to consumers. Above all, we are concerned about the system-wide problems in the debt collection market that pose risks to consumers, and we want to see good practices come to dominate the market. One system-wide problem we're concerned with is the accuracy of the data that debt collectors are using to pursue consumers. After a debt is charged off, it may be sold several times. One issue is whether a sufficient amount of information about the debt is conveyed when the debt is first sold. A second issue is the extent to which the accuracy of the information, including such fundamental facts as the consumer's identity and the amount of the debt, deteriorates as it gets passed down the line. If any piece of that information is incorrect, the consumer might not recognize the debt, and it may not even be theirs. So our examiners will be paying close attention to whether debt collectors have accurate information when they're collecting debts. Consumers also need to be able to dispute debts they believe to be incorrect. So we will look closely at how debt collectors process consumer disputes and whether they do it in a timely manner. If the debt has been reported to a credit reporting company, the collector needs to investigate all disputes and should inform the company of any inaccuracies that are found. Given the impact that a credit report can have on a consumer's life, it is critical that the credit reporting companies have accurate and up-to-date information. One noted tactic is for a debt collector to pursue a default judgment in a court, sometimes by deliberately failing to notify the consumer. The debt collector knows that the information in a credit report provides powerful influence over the consumer's access to credit, and this becomes the essential leverage for extracting payment, regardless of whether it can be justified. As part of our approach to supervision, we will encourage robust compliance programs. It is not enough for a debt collector to point to policies and procedures as a means of justifying their collection practices. The policies and procedures must be followed consistently. The best way to be sure of that is by having sound monitoring systems in place. A good compliance program also closely analyzes complaints to find patterns that may pose risks to consumers, such as whether the complaints stem from a specific employee or from a certain type of account or certain kind of business practice. We expect to see an effective and comprehensive process to address consumer complaints. The law also recognizes that debt collectors can harm consumers significantly in many ways other than pure monetary harm. Much of the law was deliberately crafted to protect the dignity of the individual consumer and to ensure that he or she is treated with the respect we all deserve. So our examiners will evaluate whether debt collectors treat consumers fairly and humanely in a manner consistent with the law. Sometimes collection methods involve harassment or deception, and they are typically illegal. Intimidation, abusive tactics, profane language, or threats of arrest are widely known to be out of bounds. Even placing certain kinds of calls, such as calls at unusual hours, is unacceptable and against the law. Wherever we find unlawful practices, we will take steps to eliminate them, thereby helping to protect consumers and, again, supporting those collectors that take care to comply with the law. Earlier this year, our colleagues at the FTC were successful in halting an operation that involved calls about phantom payday loan debt. The perpetrators somehow obtained contact information for consumers who had applied online for payday loans. Then, posing as law enforcement or government officials, they would call consumers and threaten to arrest them if they did not make good on their supposed payday loan debt. We don't need any fancy names for this kind of conduct. It is outright fraud. The FTC established that the consumers did not actually owe money to the callers, and they won a court order halting the conduct and freezing the assets of the fraudulent operation. This kind of aggressive law enforcement sends a strong warning to others that this kind of exploitation will be exposed and its exposure will be made to hurt. Our allies among the state attorneys general and other state officials likewise devote considerable time and effort to rooting out bogus debt collection efforts, including improper practices, scams, and frauds. We have been initiating our own efforts and working together with the FTC and state officials to enforce the laws on debt collection, and we will continue to do that. At the Consumer Bureau, both supervision and enforcement are key tools in our toolbox, but we have other tools as well. Another major component of our mission is to empower and educate consumers, which we're doing in part through Ask CFPB, an interactive online database that answers consumers' most frequently asked questions in plain language. Today, we're rolling out more than 70 new questions and answers about debt collection, covering such topics as the definitions of key terms, what is legal and illegal, and the best ways to negotiate a settlement with a collector. We want consumers to have an objective source of information on debt collection and one that is easy to understand. You can find the Ask CFPB database on our website at consumerfinance.gov. We also want to encourage participation in our everyday work at the Bureau, and that's one of the reasons we're holding a field hearing here today. We want to engage the entire public, including consumer groups, industry, and local officials, because we need help from all of you to promote honest practices in the consumer finance markets that will best protect consumers. What stands out most clearly in my mind today is how important it is for us to succeed in our task of fixing the debt collection market. Doing so is clearly in everyone's best interest, at least everyone who intends to abide by the law. When this market works as it should, consumers are treated fairly, they retain their dignity, and they are prompted appropriately to pay their legitimate debts. We all have the right to demand and expect as much. Thank you.
Thank you, Director Cordray. At this time, I'd like to invite all panelists to join the stage, please. And while the panelists are taking their seats, I'll take a moment to thank those joining us on live stream at consumerfinance.gov. You can follow CFPB on Twitter at CFPB to learn more about what we are doing, and you can also follow us on Facebook. The CFPB's Deputy Director, Raj Date, will lead the panel of experts through brief statements and a discussion about current trends and themes in the debt collection market. Raj Date has had a long and varied career in and around U.S. financial institutions, as a strategy consultant, as a bank executive, and on Wall Street. Previously, he served as the Special Advisor to the Secretary of the Treasury for the CFPB and as the Associate Director for Research, Markets, and Regulations at the CFPB. In 2009, Deputy Director Date founded and served as Chairman and Executive Director of the Cambridge Winter Center for Financial Institutions Policy, a private nonprofit research and policy organization that supported reform for the U.S. financial system. Deputy Director Date, you have the floor.
Thank you, Zixta, and good morning, everyone, and thank you for being with us. At the CFPB, we aim to be a data-driven agency, and that means a few different things. It means that we try to make sure that policy decisions that we make are grounded in the best available evidence. And it also means that we try to make sure that our policy agenda, as it is shaped and informed, is grounded in the pragmatism of the market as it actually exists, and that it's grounded in the actual experience of real live human beings in the consumer finance marketplace. There are a variety of ways in which we can make sure that that policy agenda is grounded in that way. And this hearing is a big part of that. We have the benefit today of having 6 panelists who hopefully will be able to inform all of us with respect to the way in which this market within debt collections actually works, how it is that from time to time it doesn't work, and what harms that may visit upon consumers over the course of time. Why don't I do this? I'd like to introduce both panels first, and then we'll ask each one of the panelists to provide a brief opening statement, and then I and my colleagues from the CFPB will take some time to ask some follow-up questions, and then we will open things up for some audience questions and testimony that Zixta will lead us through. So first, why don't I begin with some introductions, starting from the far end on my right-hand side. Is Carolyn Coffey, the supervising attorney from MFY Legal Services in New York. Next to her is Susan Shin, a staff attorney from the Neighborhood Economic Development Advocacy Project, also in New York. To Susan's left is Dick Rubin. He is a consumer law expert with a long-time, 4-decade history of practice out of Santa Fe, New Mexico. If I turn to my left, all the way at the end of the table, we have Chad Benson, the Chief Operating Officer of CBE Group. Next to him is Bill Allen, the Chief Executive Officer of ALW Sourcing. And then Carrie Finney, the President and CEO of the CMI Group. With that, perhaps we could start with you, Ms. Coffey, with a brief opening statement.
Thank you, and thank you, Director Cordray and the CFPB for holding this really important hearing today on debt collection. I'm really pleased to be here, and I welcome the news that Director Cordray just spoke about. I work at MFY Legal Services in New York City. We provide free civil legal services to low-income New Yorkers, and we also engage in law reform, impact litigation, and policy advocacy. I supervise our Consumer Rights Project, and we have a weekly hotline that consumers call, and we're also actively engaged in consumer clinics in courthouses around New York City, where we help pro se litigants. So we talk to consumers at every stage of the debt collection process, from individuals who haven't yet defaulted on, say, a credit card debt, but they're worried about paying next month's bill, to people being harassed by multiple debt collectors, to people facing debt collection lawsuits in court. Some of the recurring problems that we see, especially with debt buyers on a regular basis, is unrelenting collection efforts against people with exempt income, improper service of process of lawsuits, and meritless cases brought by debt buyers who can't show that they actually own the debt that they're suing on. So what does abusive debt collection look like? I have sick and disabled clients who survive on supplemental security income, which is only about $700 a month, not a lot to live on in any part of the country. They get calls and letters from debt collectors who try to convince them to pay, even when they know that they're disabled. Many of my clients want to repay their debts, but they barely have enough to pay for food, medicine, and their rent. Someone like my client Charles, a veteran who's mentally ill, shouldn't be coerced into working out a settlement plan with a debt collector just to stop harassing phone calls and letters. Our client Karen, who's had 6 surgeries in the past 2 years and is unable to walk or work, she survives on Social Security, and she notified a debt collector of her situation and her inability to repay a credit card debt. 2 weeks later, the debt buyer sued her anyway. We also constantly hear from consumers who don't know they've been sued until long after the debt collector has won its case and entered a default judgment against them. These people find out they've been sued the hard way, like our client Sarah, who was unable to withdraw cash from an ATM to get home to Staten Island from her job in New Jersey because her bank account was restrained due to a judgment on a case that she didn't even know about. Problems surrounding improper service of debt collection cases exist around the country, and it really puts consumers in the worst possible position. Many people will agree to pay a debt collector the money that's restrained in a bank account out of desperation, rather than risk their next paycheck being frozen as well. We also see frivolous cases being brought in court. We've got many clients who are victims of stolen and mistaken identity, whom the collector can't possibly prove their case against, but they pursue those claims anyway. My client Monique is a stay-at-home mom whose husband is an electrician. She was sued for a debt she knew nothing about, and it didn't appear on her credit report. And the person who sued her, the debt buyer who sued her, she'd never heard of either. She asked for documentation repeatedly from the debt collector's lawyers. She appeared several times in court. They couldn't provide anything to her. These meritless cases are really drowning the country's small claims courts, and we see this every single day. These are not isolated problems or stories. They really exemplify this widespread systemic problem that desperately needs reform. Thank you.
Thank you, Ms. Coffey. Ms. Shin.
Good morning, and thank you to Director Cordray and the CFPB for inviting me here today. I'm a staff attorney at the Neighborhood Economic Development Advocacy Project, or NEDAP, which works to promote economic justice in low-income communities and communities of color in New York City. And at NEDAP, we convene a statewide coalition called New Yorkers for Responsible Lending. We bring litigation to address abusive debt collection practices and unfair bank practices. And we also run a legal hotline like MFY, where we hear from low-income New Yorkers on a range of financial justice issues. And at NEDAP, we are constantly flooded with calls from people, often very low income, elderly or disabled, whose lives are being devastated by these abusive tactics that Carolyn just talked about. Because of frozen bank accounts and wage garnishments, people can't pay their rent, they can't pay their bills. Because of judgments appearing on credit reports, people are unable to find housing or increasingly jobs because more and more employers are checking people's credit reports when they apply for jobs. And the reason we work on debt collection issues at NEDAP is that we see debt collection as one of the most abusive financial practices that are harming entire communities. We found that in a 2.5-year period, debt buyers had actually extracted over $1 billion in judgments against New York City residents. And we see that these lawsuits that Carolyn mentioned are overwhelmingly concentrated in low-income communities and in communities of color. So we see this not just as a consumer protection issue, but really as an economic justice issue that's affecting entire communities and really is an extension of the systemic predatory lending practices that have been draining wealth from these communities for so many years. These problems are really happening because the debt buyer industry has been able to operate in this environment of no accountability for a really long time, and it's a national problem. Industry-wide, perpetrated mostly by these debt buyers and the debt collection law firms that they hire. These debt buyers include huge publicly traded companies, for example, Encore Capital, Asset Acceptance, Asta Funding, Portfolio Recovery Associates, as well as big and small private companies. And what they do, they have this business model that relies on buying debts extremely cheaply for pennies on the dollar. And when they buy debts that cheaply, they're not actually buying any substantiating documentation that would allow them to respond with verification of a debt when someone disputes a debt, or to provide any proof in court when someone is sued on a debt. And they aggressively collect these debts anyway, even with all of these problems, and they've been getting away with it for years. And the worst of it is that we found that a lot of the debts that people are being harassed on or sued on aren't even legitimate. There are problems with the debts being the result of identity theft, mistaken identity, debts people are being pursued for that have actually been paid or settled already or discharged in bankruptcy, debts that are too old to be sued on, and so on. It's been widely reported in even industry press the problems that of accuracy that riddle the debts that are being sold by these banks and other debt buyers, down the chain to more and more debt buyers. Even when the buyers and sellers both know that there are problems with inaccuracies about the balances, that the portfolios include debts that were already paid or discharged in bankruptcy, they're still going after people aggressively with these lawsuits and other tactics. So at NEDAP, we're seeing these problems on a daily basis, and we really urge the CFPB to take strong action to stop, to end this environment of no accountability for debt buyers. And we really see this as a critical opportunity for the CFPB to address these issues by writing strong rules and engaging in very close supervision of the industry. And we would be happy to share our ideas with the CFPB going forward.
Thank you. Mr. Rubin.
Thank you. Thank you very much. I wanted to, when I was invited to come here today, I wanted to talk about what I have seen over, almost 40 years of working in this area. I've been working in this abusive debt collection area so long that I got started before the FDCPA even was adopted. And one of the things, there were two things I wanted to talk about. One is something that's changed over that period of time. The two greatest abuses I see are, one, the abuse of the court system. After I found out who my colleagues were going to be on this panel, who have devoted their careers here to doing the most extraordinary work, fighting the abuses of the debt buyer industry and the abuses of our court system. That's who ultimately is being abused here. What is being abused here? Our court system. I don't think I need to add to that. I want to go to the second one, which hasn't changed in, well, unfortunately, it has changed. It's gotten worse over the 25 years that even since the FDCPA was adopted, to stop the practices, and that is the abuse of consumers through the intrusion into their homes, the abuse of the privilege of calling people on the telephone. It is you want to know what are the abuses in this industry. Well, the data have been collected for years by the FTC and now by the Bureau. This wonderful 2012 Fair Debt Collection Practices summary that the Bureau's first summary that's been done, we'll be doing every year, attaches the data. Over 50, the debt collection, as the report points out, is the largest area of consumer disputes. The largest number occur through debt collection. And the largest number, more than half of them, involve telephone abuse of one sort or another. There's really only three reasons why a debt collector would ever telephone a person at their home. This is one is to inform the person they owe the money and that they owe it to this person. Two, to give them an opportunity to pay the debt. And three, to advise them of what are the consequences, the realistic and actual and reasonable consequences of non-payment. We've got records here of over 50,000 collection calls the topic area is repeated calls. Every one of those people who reports an abuse to the FTC or to the Bureau tells virtually the same story. And that is, I got a phone call. Yes, I heard that, they go through the talk-off. You owe the money, we owe it now because we're a third-party debt collector. Can you pay it? If you don't, sometimes they come up with threats, or almost always, we're going to sue you. If those threats are actual, legitimate, and intended, there's nothing wrong with making that threat. And then, always, it ends the same way. The consumer says, I can't pay you. I cannot pay you. That is what we know from the data also, that everybody, virtually everybody who owes the 30 million people that Director Cordray mentioned, they all would pay the debts if they had the money, at least for those who have the right people, that they're dunning the right person. So it ends always with the comment, I cannot pay you. We're out of work. We haven't been, no one has worked here for the last, 3, 4, 5 years. Sickness. Is, of course, the second largest reason why people don't pay debts. And that's the end of the conversation. What happens next? The next day, you get another call. The day after that, you get another call. Why are they calling? Except to annoy and harass. Because in those business models of those debt collectors who make the phone calls, they have one objective. And that is to make people who have no money to pay the debt, to make their lives so miserable, to motivate them to this month to pay this debt collector on these old debts they barely remember, rather than paying the electric bill, the rent, the medical debt that's owed, current debts. This is the business model. And let me close by saying on this portion that Director Cordray, you're absolutely right, mentioned in the introductory portion that it's so important, and that the auditing and examinations that the Bureau is about to do, we so welcome, that we ensure that the collection industry follow its own policies and procedures. In this group of predatory debt collectors that I'm speaking about, the policies and procedures are exactly what I'm saying. To annoy, harass, they have no reason to call somebody. Now, if you pick up the paper, you're a collection agent, and you pick up the paper the next morning, and you see that so-and-so won the lottery, it would say, oh, didn't we call him yesterday? Okay, sure, give another call. Maybe they can want to pay. Or maybe they have some information that says, that for whatever reason, including that the consumer may have given, that says that I expect to start working. I've found a new job. Yes, call back and give another opportunity to pay, because that's a legitimate reason. Every other call is only for the purpose to harass and annoy. And that's what I hope will be one of the results of ending that behavior, will be one of the results of the initiative you're announcing today. Thank you.
Thank you, Mr. Rubin. Thank you to each of our three consumer panelists for their opening statements. Perhaps we could move to you, Mr. Benson, for your statement.
On behalf of the CBE Group, I'd like to express our appreciation to the CFPB for conducting this very important public service. I'd especially like to thank Director Cordray, Deputy Director Date, and the CFPB staff for preparation and participation today. I'd also like to thank my fellow panelists and those who have taken the time to attend. My name is Chad Benson. I'm the Chief Operating Officer at the CBE Group based in Cedar Falls, Iowa. Today, CBE's core business provides first and third-party collection and recovery work for a diverse group of clients nationally, with nearly 1,000 dedicated associates. The size and scope of the debt collection industry is substantially larger than most people realize. More than 4,000 collection agencies are licensed to operate nationwide, ranging from small-owned businesses to large globally run enterprises. An independent survey conducted by the ACA and Ernst & Young in 2011 revealed that debt collection industry provided over 3,000 direct and indirect jobs, recovered $55 billion in gross collections, provided significant contribution to both state and federal tax receipts, and provided the leadership for creating 85 million and 650,000 hours of charitable giving. It is unfortunate it only takes a few unethical industry participants to create extremely negative image for the industry, which we are working overly hard to correct. It goes without question, our industry has the opportunity to deliver better experience for the consumer through the leadership and action of every individual, regardless of the role they may play in the process. The CFPB, consumer advocacy groups, and the collection industry can create a win-win outcome by modernizing outdated laws which govern the collection of consumer debt. We need to put consumer protection in the forefront of our discussions and find reasonable processes that will protect the best interest of the consumer. The FDCPA was enacted in 1977 to provide a uniform set of regulations to govern the early evolution of the collection industry. The guiding principles that led that creation some 35 years ago are equally important today. However, over this time, the FDCPA has seen little to no change. Over the past 3+ decades, consumer communication has gone through major change, especially as it applies to technology. Technology has developed to a point where call centers have the capability to systematically and efficiently provide the means to execute compliance. Examples of this evolution have been call recordings, the utilization of speech analytic technologies to monitor, review call compliance with regulations, compare a consumer's area code to zip code to ensure that calls placed within these prescribed time frames are adequate, limit the number of calls made to consumer phones over the same day, multiple times a day, or frequency within a day, and allow agencies to maintain internal do-not-call distributions. These are just a few things that technology has brought to the capabilities for debt collection and call center business alike. The basic thought for improving clarity and transparency to FDCPA can provide the catalyst for collection industry to continue to build on accountability and responsibility it has to effectively execute. Harassment claims have been the leading consumer complaint against debt collectors since 2008. 40.4% of FDCPA, or 47,362 complaints received by the Federal Trade Commission in 2011, claimed debt collectors harassed complainants by calling repeatedly or continuously. The FDCPA ambiguously identifies how often a debt collector may attempt to contact a consumer related to the delinquent obligation. The current definition of repeatedly or continuously does not provide the adequate level of understanding nor protection for consumers while balancing responsibility for the debt collection or debt collection industry to contact consumers for the unpaid or delinquent monetary obligation. The facts are clear. We've reached an interesting intersection where regulation and technology can provide consumer protection into the future. We are honored to participate in today's panel, and I would say personally that it would be a really good step forward if the CFPB, the industry advocates, the collection industry could work hard to create a fair framework that allows consistency, clarity, transparency, and measurability into the gaps that exist today in the FDCPA. Thank you.
Thank you, Mr. Benson. Mr. Allen.
Good morning. My name is Bill Allen, and I'm pleased to be able to contribute to this important forum. So let me say thank you to the wonderful city of Seattle. Thank you to the congressman and the mayor that has come here in this forum and is openly and willingly to talk to us in this type of discussion. ACA for your guidance and making sure that we are consistent in our insights into how we can all do a better job for our consumer as well as our customer, and yes, even me as a constituent. Thank you, my fellow panelists. Thank you for bringing out the information that you have, but more importantly, for your expertise, in my opinion, is very vital in ensuring that members of our industry, large, that I had mentioned earlier, small, as myself, have been put in a strong advocate group so that we can have strong ties to the community and to the consumer. But most of all, thank you, the audience, the folks here in Seattle that has taken the time out of their busy schedule today to come here. But what I'm mostly important and what I'm very concerned and what I'm very interested in is that I want your input. I really want to understand your concerns and how we can do a better job. My primary goal, well, Bill, what is your primary goal? Thanks for asking. For this exchange, my primary goal is to listen. I really want to listen and understand. I've heard the experts on this side of the panel, but I really want to hear you. I want to understand what we can do in the industry to make a difference, so that you can understand a little bit about my perspective, why I may say certain things and why I may act and why I may move certain ways. I'm the founder and the chief executive officer of a relatively small collection agency based and headquartered out of Maryland called ALW Sourcing. We are happily to say that we make a difference in our community, we make a difference in our charities, and we also make a difference in the economy. Our clients are quite simple. They are in 5 different verticals. They're in the banking industry, the telecommunication industry, the utility space, as well as the education sector. You may ask also, well, what do you do? Well, in each case, we offer and provide services to collect rightfully owned debt and provide customer service in all of our customer contact centers. Even as a relatively small agency, we have seen and continuously to see an ever-increasing emphasis on customer experience. In my centers, it's quite clear. We're measured on 3 factors. 1, CSAT, that's the customer satisfaction score, that is very dear to us to make sure that your satisfaction is done. 2, AHT in the industry, better known as average handle time. We want to make sure that we handle your call properly. 3rd and final, 1-call resolution. Did we solve your problem? Did we handle your problem accordingly? Our clients, your creditors, like many, are looking for the same thing. They want to make sure that they preserve their customer. They want to make sure that they have the opportunity to expand their customers, and they want to protect their brand as well. The things I learned here today, we will have the opportunity to take back and have a clear understanding how we can better serve their goal. It is important for businesses that we provide the goods and services not just to my customer, but also to you in the community. It is important for the businesses in our industry that so much is part of this sea chain. And I repeat, this sea chain towards a focus on the customer experience. It is important for the growth of small businesses like mine that we are seeking here to educate the consumer on how we can best balance, keyword is balance, their obligations with their rights. I think we can do it. I really do. I think that by having open forums like this, I know that a forum like this is one start. It is always a step in the right direction. Thank you, and I'm Bill Allen.
Thank you, Mr. Allen. Ms. Finney.
Good morning, and thank you for the opportunity to speak about some of the topics that are very important in the industry. My name is Carrie Finney, and I'm the president and CFO of the CMI Group. It's located in Carrollton, Texas, and we employ 287 people. I've been involved in the collection industry for 14 years now, and over that time, I've witnessed a number of changes in the laws and regulations governing our industry that have greatly altered the way that we do business. While many of these changes have been good, both for the consumers and the creditors alike, others have created greater confusion over what collectors can and cannot do in the pursuit of a just debt. At present, the debt collection industry is regulated by a number of laws. We are also forced to contend with 50 states' legislators, 50 different state regulators, and 56 different attorneys general. And while they all have the public and the economy's best interest at heart, they do not always provide clear and consistent rules for our industry on how to operate in a compliant manner. Fortunately, members of the industry have organized in order to pool their collective knowledge on regulations from one state to the next. Trade associations like ACA International have even created training materials and continuing education programs to help its members navigate the complexities of an ever-changing legal landscape. Conflicting and confusing laws make our job more difficult at times, but the creation of the CFPB may alleviate some of our concerns if it uses its powers to modernize the laws that govern us and to create some uniformity across the patchwork of laws that we currently have to contend with. Thank you for your time.
Thank you very much. We'd like to take some time now to follow up on some of the issues that were raised in the opening statements through a Q&A period. And helping me do that are some of my colleagues from the CFPB. You've already met our director, Rich Cordray, and our head of external affairs, Zixta Martinez. And we also introduce our assistant director for non-bank supervision, Peggy Toohey. And despite the fact that I have all of this assistance, I will nonetheless take the liberty of asking the first question, specifically directed to our consumer panelists. Each of you laid out a taxonomy of practices that may be problematic because they may be not fair, they may be not equitable, they may visit unexpected or unnecessary harm. But a different way to think about some of these problems is with a vision for the future. In other words, what would a functioning, more appropriate debt collection marketplace look like? What should we be working backwards from? If each of you could just briefly address that question.
Well, I would say that the whole business model of the industry requires some fundamental changes, and I think the CFPB can play a big role in enacting strong rules that, for instance, require debt buyers to have and provide much more information about the debt. Currently, people are being contacted about debts and just may not even know what it's all about, how much they really owe. So I think that would go a long way. I think another thing is that when people are entering into settlement agreements, sometimes we've heard from people who can't even confirm what their current balances are. They can't even confirm that their payments have been received and credited correctly. So I think enacting rules that address those kinds of issues would also help.
You know, this is, as it has been for 35 years, the reason that Congress federalized debt collection. It's actually an extraordinary step if you think about it in terms of the normal relationship between Congress and the states. The culture of the debt collection industry 35 years ago and today remains one of non-compliance with law. Not every participant, of course, but the culture is non-compliance. The culture is to devise strategies that go as close to the line as possible, supposedly without passing over that line, and employing them to get a competitive advantage on the next debt collector, whether it's a third-party debt collector or, as I mentioned earlier, just the everyday bills that people have to pay. That culture has to change. The norm in this industry needs to be compliance with the law. That will be success. The normative behaviors need to reflect compliance with each provision of the law. Right now, it is the opposite. It is absolutely the opposite. And that, I think, is what it needs to look like. How will you know? How will we know when we've reached that goal and when you've reached that goal? When debt collection complaints are not 150,000 a year to the Federal Trade Commission, but the handful that we get, that the Federal Trade Commission, the Federal Reserve Board gets on truth in lending, for example. There's a successful consumer initiative. Truth in lending, over 40 years ago it was adopted. There are problems, of course, in the credit marketplace too, but the disclosure, misdisclosure, non-disclosure of terms of credit is not a problem to speak of. It's not anything anyone is going to prioritize right now. That's been the result of 40-some years of truth in lending, compliance, auditing, etc. When that day comes with debt collection, then we'll know that we had success.
Thank you. Ms. Coffey, what does success look like?
I would agree with my colleagues. I think advocates have been really chipping away at the problems that we see in debt collection across the country, but there really is a regulatory void, and I think this is a great time for the CFPB to fill that void and really rein in debt collection abuses and really just ensure that legitimate debts are collected and that the people collecting the debts are the proper owners of those debts. And I think real rules and regulations would go a long way, as well as strong supervision.
Peggy?
Thank you, Raj. We've already heard from Carolyn and Susan in particular this morning about the issue of inaccurate and incomplete information that flows through the debt collection system. And I thought, I'll come back to you, but I thought, could we hear from the industry panelists what your perspective is on this issue? Do you think inaccurate and incomplete information in terms of making sure that the information can show who owes the debt, that it's the right amount, that it can be verified, is that a problem? How much of a problem? And what are the possible solutions? Chad, if you...
Yeah. So I think that the most part, if you start from the origination of credit and you think about the process of credit moving through to a point where it's delinquent and then charged off, I think that we've seen over the course of the last decade a substantial improvement in the amount of information that is flowing to the debt collection industry as it relates to account level information. I think, like in any system or process, that it's not perfect. And I think that when you look at how today we would go about processing things like disputes or discrepancy in data, I think those processes are the things that are most important to look at. Is we certainly would not want to collect on a debt that somebody is disputing and, by matter of fact, is not theirs. I think the industry is clearly not signing up for that. So I think the evolution has come a long way over the last 10 years, but we still have room to go.
And do you have ideas for how to prod the further evolution along?
Well, I think it's choice, right? So I think as much as you have choice to say yes or no as to who you would do business with. And, I think that's a kind of a novelty. But if you're knowingly getting information that's not correct, then I would suggest that people just stop dealing with those individuals, frankly. In the case where information is changing and more information is being made available, I think good dialogue with creditors and issuers related to things that are coming up and being able to capture more information is something that just having a good collaborative environment where that information is flowing. Because for the most part, people are good. They want to get you the information that is needed, and they want to put the processes in place that are going to allow for consumers to have things like final billing statements and information that would help validate the information they may be looking for in a timely manner.
Bill or Carrie, do you want to add to that? Or?
Just that we take we take it seriously to ensure that we have the correct information when we are collecting on a debt. And we do have to rely on the information initially that's provided by the creditor, our client. And when we do get disputes, we work seriously with our clients to resolve them and come to a resolution and get the right information.
Bill?
Real brief, just to piggyback on what Chad said. I, too, have had 25-plus years in the space. The good news about that is I spent time with the credit reporting industry, where I worked for Equifax as well as TransUnion. And I think that piece is probably part of the key, is the origination of the information that we get up front must be accurate at that time. Is there room for improvement? Absolutely. How can we do it? I think by having a bureau like CFPB, I think that's going to make a huge difference so that we can all get together, gather the information up front, and make sure the information is accurate by the time we receive it on the back end.
Thank you. Carolyn or Susan, you've already talked about this. Do you want to add more and talk about what you see as possible solutions to the issue of data accuracy and completeness?
Sure. I mean, I'm happy to hear what my colleagues are saying. I think, in real world practicality, I mean, we have clients. I have a client, Josefina, who had one credit card. She was a Spanish-speaking immigrant. She paid her credit card religiously, regularly every month, and one month there were charges on it from Bangkok, jewelry, luxury goods. These were not purchases that she had made. She disputed with the bank. That debt was, regardless of the fact that she had disputed it, that debt was sold to a debt buyer who tried to collect on it, and then ultimately sued her on the debt, even though this was clearly not her debt. It was not a lawsuit that ever should have been brought. It wasn't an account that should have been sold. That's not an isolated incident, and I think we see it in the purchase and sale agreements that we've reviewed from companies that buy debts from original creditors, and there are clauses that say that we have no, we don't have any proof or we make no assurances that the information that we're selling is correct. We have seen clauses that say that you have no right to go back and request additional documentation or proof or evidence of the accounts. And I think that's really troubling. And I think you want to add to that?
I would just add that even when, for instance, in litigation, when defendants are asking for documentation, sometimes these debt buyers and their law firms are providing documentation they purport to be proof, but in fact may include account agreements, for instance, that actually post-date the date when the person opened the account. And we've even seen and heard of account statements being produced where the person's most recent address was printed on the statement, even though the statement predated when the person moved to that address. So these documents are, even when they're presented, are really being manufactured and being presented as purported proof of these debts.
So in terms of possible solutions, the FTC has recommended in the past that media or certain types of media and quantum of media be included in the sale of debt when it's first sold. Do you think that's part of the answer, or what are the solutions here?
Yeah, I think that would be great. I think rules that say that if you're collecting on a debt, you have to have, if you're collecting on a credit card debt, you have to have a copy of the contract, for example, before you can actually try and contact someone. So it's that person that they signed a contract and their name is on it, so that if you have proof of how the amount that's being collected on was calculated, if you can show that this is the principal balance, these are the fees, this is the interest. I think requiring those things at the beginning will help in terms of collecting, right? You're actually collecting a legitimate debt, and you have those things in hand when you're collecting, and then if you file a lawsuit, you have your proof right there. Right now, it's just a free-for-all.
One thing I would mention that I think is very important, Ms. Finney mentioned that we want to ensure that the information is accurate. No one knows if this information is accurate. The creditors don't even know the information is accurate. And as was just mentioned, when they sell the portfolios, they normally disclaim the accuracy and reliability of the information. That's, again, normative behavior. One thing that we all ought to keep in mind, and why we can't ensure the accuracy of the information is what is the value of these portfolios? What is it really worth? The market has determined that. A penny on the dollar, 2 cents on the dollar is what the market has determined is the value of a portfolio of debt that's worth millions, tens and hundreds of millions of dollars. If the market thinks it's worth a penny, some of it's less than a penny a dollar if it's old enough. I haven't seen anything in years more than 4 or 5 cents on the dollar, even for first generation debt. The market, the people that sell and buy this information know it's unreliable, and the price paid is an indication of that. That defines the problem we have right now, and the idea that when you have these agreements that the creditors say that not only are you buying this portfolio, but you agree, and your assignee and the assignee after will never come back and ask us for more information. This helps explain what the problem is. I hope that technology will, in fact, make a difference. It's one of the few areas that I think technology has exacerbated many of the harassment problems, but it may solve this problem.
And just quickly, I think one concrete solution would be for the CFPB to write very strong rules around the verification requirement of under the FDCPA, since that has been so dramatically watered down by the courts.
Perhaps we could pick, and by the way, I should note, I don't know if it's if you can hear it over the video or not, but as we talk about some problematic practices and tales of human misery, we can hear anyway, peals of laughter. It is not because the audience has a bizarrely inappropriate sense of humor. It is because there must be delighted children somewhere behind this wall.
Because they don't get any debts.
They've been crying too, Raj.
Because children rarely owe anything. Rich is pointing out. Let's pick up on this notion of technology and technological change. Mr. Benson, you mentioned it through let me just paraphrase. You mentioned two aspects of it. One is sort of the notion of conducting the core business in a more efficient way, but also the notion of allowing better compliance or control over operations over time. Could you just elaborate more on that, and particularly in light of you have a multi-decade-old regulatory framework. Presumably, that regulatory framework has not kept up in some places. What would you call out in particular?
Yeah, so I think one of the issues that I think was brought up and is probably relevant is this whole notion of repeatedly and continuously. And I think when you look at the FDCPA and you step back and ask, okay, so would you put 5 consumers in a room and could they clearly define what repeatedly and continuously means and how that applies to what they could or couldn't expect, and now transpose that to an industry with over 4,000 collection agencies, and now ask those 4,000 agencies to interpret that and get it right, I think that's pretty daunting. I do think that technology has allowed for the industry to do a number of things over the course of time as it relates to telecommunications, but it's also given way to the ability to protect non-public information. The evolution of the databases and the collection systems have gotten better and stronger as it relates to processing and the different things you can do at that level. So I think, we've got to address the idea that the FDCPA does fall short when it comes to repeatedly and continuously, and figure out how we can eliminate and bring clarity and transparency to that for not only consumers but for the industry, because I think most good people we want to figure out and make sure we get that right.
Mr. Allen and Ms. Finney?
Technology, the laws have not kept up with technology, and we need to update those laws so they're consistent with what's out there, the means that we can communicate with customers now, and the means that they want to be communicated with. So we need to revamp those laws a little.
What are the just to follow up on this notion of small claims courts being kind of inundated by volumes, et cetera, you've pointed to ways in which technology has changed. Dialer technologies are different than multiple decades ago. Telephony just generally is much cheaper than it used to be. But presumably, multiple decades ago, there were state courts, and there are state courts now. What is it to your mind, has changed sort of the contours of the demand for state court filings and litigation? What has been driving that?
Well, I would say that obviously the the ability for the evolution of the debt sale environment, the creditors have increased litigation processes on their accounts as they've flowed through charge-off. I can't speak specifically to how other folks would go about making decisions relative to what makes them decide whether they sue somebody or whether they try to communicate with them effectively on the phone before they go through that process. But obviously the increases in that process have made a big impact. I think in some ways too, where information is valid and there is situations where consumers do choose not to want to pay and they have the means to pay, that is an effective opportunity for creditors, issuers, debt purchasers that own the chain of title and all the relevant information to process a legitimate suit to be able to do that. And so it's not like it's not an effective practice. It just needs to be done right.
Why don't we, I've found over time that it is best to make sure that Zixta has the last word on things. So Zixta, I literally have been hogging your microphone, so.
Thanks, Raj. This is a question for all the panelists. It would be interesting to hear from you all, what are the two things that consumers should know about debt collection? And why don't we start on this end with Ms. Coffey?
I think one important thing that consumers should know is that some consumers' income is exempt from collection, and things like Social Security, disability, veterans benefits, and so I think that information is really reassuring to consumers, and when they know that worst case scenario, even if they are sued on a debt that they may or may not owe, that their sole source of income can't be taken from them, and then I think that the consumers should really know, they should know that they do have rights. They don't have to change their phone number to escape harassing phone calls. They don't have to feel victimized by debt collectors. I think those the laws that protect them could certainly be strengthened, but even now there are some protections, and people are not aware of that, and I think it's important for people to know that they don't have to feel abused by the debt collection industry.
I would echo what Carolyn said. I might add that I would want to also tell people about filing complaints with government agencies, especially the CFPB, and I will certainly be referring our clients to the website and the Ask CFPB module. So I think that's really important to raise awareness among the enforcement agencies about who these entities are, and I really think there was some allusion to this being a bad apples kind of problem, but we at NEDAP and MFY, and we've heard from advocates all across the country, this is really pervading the whole industry. So I just wanted to make that point.
There's one thing that consumers need to know that unfortunately the FDCPA does not require disclosure of, and that is the cease communication rights. Again, people do not have to put up with these phone calls. All they have to do is write a letter under the FDCPA, under federal law, that says, I refuse to pay this debt, I can't pay the debt, I dispute the debt. Any of these things means they have to stop calling, have to stop. And then last year, the FTC received 5,922 complaints from consumers who sent these communication letters, and they still got phone calls. It's a chilling statistic. But that is the most important right that you have. And I hope that when the regulation writing comes under this by the Bureau, that needs to be an addition. That right needs to be disclosed in every communication. Congressman Frank introduced a bill earlier this year that apparently isn't going anywhere with everything else in Washington, that has a directive to the Bureau as part of dealing with the phone call issue, that directs the Bureau to adopt regulations that will require the disclosure by a debt collector in every communication with a consumer the right to cease communication. That is the most important right people have. They don't know about it, most of them. And the ones that do, the industry still doesn't comply with, apparently. There's so many rights, but that's the one that I would say is number one.
Chad?
Yeah, thank you. So I think that one of the things that would be important is that, there are a lot of good people out there that are trying to help consumers who have fallen on tough times, that have legitimate debts, that are trying to help them get back on their feet. And so, the opportunity for them to engage in that process in the effective way, I think, is important for any consumer to know and understand. I think the other thing is that, the FDCPA, as I said, just falls short on many ways from a clarity and transparency perspective. And I think it's time, that for their perspective, that we are protecting them through the opportunity to work together to clear that whole process up so that we can all be effective and they understand their rights and so forth.
Okay. The notion that collection agencies, a call centers period, wants to take the expense and continue to call you over and over and over again when you're not going to pay is mind-boggling to me. No one wants to call consistently, not to suggest they don't, because they do. Those complaints wasn't just creamed up, they actually happened. There were some bad actors, and we need to get rid of those bad actors. And I think by having the CFPB here, I think we can eliminate those, at least reduce them tremendously. And I think what you'll find there, I think we will find that those numbers will reduce that we've just heard. The second part of that is, no question in my mind that when you do have the opportunity to speak with a customer, and I refer to them as a customer, that if they have what I call the WA formula, the willingness and the ability to pay, then that is the call. If they do not have one of those two, the call should cease immediately. Because without the willingness, as well as the ability is there, or the ability without the willingness, we do not want to continue the conversation. The call should cease immediately. So the piece is, I think we should do a better job in educating our consumers and our customers on the laws to make sure they understand this cease law that we just heard. I think that's absolutely a good point. And the second piece is, make sure they understand what their rights are so that they do have the willingness and the ability to pay. Most of our customers are good people. They either had one of the 3 Ds. They either had a divorce, they either had one of the disability, or they now are sickness and they can't do it, or but they've been disbanded, they're unemployed. Mm-hmm. There is some fraud, but for the most part, we know that fraud is minimal. So they're good people, and we just want to have the ability to make sure there's a good balance, the balance of the ability to pay the debt and the ability to understand their right.
I think that balance is key. Collection industries, we would like to partner in the solution to find that balance where consumer protection is taken care of, but it also allows for us to collect on rightfully owed debts. And we'd like to be at the table in those solutions when collaborating with the CFPB, the FTC, Congress, all those things.
Thank you very much. I'd like to draw to a close this phase of our hearing, and I hope that all of you will join me in thanking our panelists. I mean it quite sincerely. You are all quite busy people. You come from every corner of the country, and it is really quite core to our work to be able to make sure that our efforts in this area and others are grounded in the reality of the marketplace and what consumers are seeing day to day. So thank you again. Sixta?
Thank you.
Yep. Thank you. At this time, our guest panelists, could you please rejoin the audience?
Okay.
Now it's time to hear from participants who are here with us today. I'm told that in our audience we have community leaders, advocates, industry representatives, residents, consumers, and perhaps a few additional elected officials. We appreciate that you took the time to be here this morning and to participate in this field hearing. I thank you in advance for that, and I also apologize in advance if I inadvertently mispronounce your name. So the open mic portion of today's field hearing is really an opportunity for the CFPB to hear about your experience with consumer debt collection, to hear about what is working well in the market and what is not. Each person has 2 minutes to tell us their story and experience with debt collection market and practices. What we hear from you is invaluable. And we'd like to hear from as many of you as possible, so I encourage you to observe the 2-minute limit so that everyone who signed up to tell us their story has the opportunity to do so. Our first witness is Sally Mary De Leon.
Hello, and thank you, CFPB, for putting this forum together and for allowing me to share my story. My name is Sally Mary De Leon, and I am a single mother with 2 children, and we live in Bellevue, Washington, under the HUD-VASH program, which is the Veteran Affairs and Homelessness program. I am here today because I am someone that has been directly impacted by debt collection, and I feel that it is important to speak up. I would ultimately like to see debt collectors to stop taking advantage of poor people like me. My story starts when I went through a divorce with my abusive husband. I went from a 2-person income down to 1, and at the same time, because I had a 3-1 ARM mortgage, my loan payments went from $1,600 a month up to $2,600 a month in less than 3 years. I had no idea what a 3-1 ARM was and what was happening. As a result, I couldn't catch up with the payments. I ended up being deeply in debt and had to file for a Chapter 11 bankruptcy. Then came up all other problems. All my debts, included the bankruptcy, were not collectible anymore, but the debt collectors kept calling me and trying to collect on old debts. I would tell them that I had filed for bankruptcy and I didn't owe them this money anymore, but they would still call. 3 months later, a different agency would call for the same debt, and it just wouldn't stop. I had an attorney that was helping me. He told me that that under the XYZ law, it's been discharged under Chapter 11, and if I needed a letter, he would write the letter for me, and it would cost me $50. This harassment by debt collectors happened for over 1.5 years, and I was harassed by 3 different creditors under the same debt for money I didn't owe. This whole experience has negatively impacted my personal progress and self-esteem. Every time the phone rang, I felt like I was, either doing something wrong or I'm being abused over again, that I needed to cower and hide. I just wanted to put the whole thing, the whole mess behind me, but I couldn't because of the repeated harassing phone calls. My hope today is that we can start holding debt collectors and creditors accountable. They continue to hold consumers and people like me accountable for our debts. We are doing the right thing, so why shouldn't they? Thank you for taking the time to listen to my story.
Thank you for sharing that with us. I know it's not easy to share such personal experiences. We greatly appreciate that you did. Our next witness is Brian Fair. Nice to see you, Brian. Matt Mavestadt. Marcy Bowers.
Good morning. Thank you so much for taking the time to hear from us. My name is Marcy Bowers. I'm the director of the Statewide Poverty Action Network. We're a statewide advocacy group dedicated to ending the root causes of poverty in Washington state. As a statewide organization, it's essential for us to know what issues people living on low incomes are facing in their communities. Every year we travel across the state to hear from community members. And for the past 3 years, we have heard stories, many stories in fact, about family debt and debt collection. Many of the people and families we interviewed were in debt simply because they had the unfortunate luck to get sick. For example, this summer we met Melanie, a 23-year-old also from Bellevue, who owes $73,000 in medical bills at the age of 23. As if getting sick and owing more than you could hope to repay isn't challenging enough, predatory debt collectors are exploiting already struggling Washingtonians like Melanie, often leaving them in worse financial situations. Time and again, we hear stories from people who've been trapped by high fees and deceptive practices. For-profit debt-related businesses have seen rapid growth over the last 5 to 10 years in our state, and protections for consumers simply have not kept pace. I will focus today on one particular subset of the industry, debt settlement companies or debt adjusters. These companies charge people large amounts of money to purportedly help people pay off their existing debt and offer to negotiate on their behalf. The debt settlement model usually requires that people stop paying their creditors. Unfortunately, this model of settling debt rarely works. An audit conducted by the FTC of nearly 45,000 records from a single debt settlement company revealed that less than 2%, or just 638 customers, completed the program. Instead, consumers are usually suffering reduced credit scores, the escalation of collection actions by creditors, wage garnishments, collection lawsuits, and even bankruptcy. Last month, we spoke to Jenny, a low-income woman in Walla Walla, which is in southeastern Washington, about as far away from here as you can get, who told us her heartbreaking story of getting involved with a debt settlement company. She owed $15,000 in medical bills. In order to help settle her debt, she emptied any savings she had and over time paid $8,000 to a third-party debt adjuster. Only later did she find out that not a penny of it was applied to her debt. She wanted to get a lawyer to fight it, but she couldn't afford it, both because of her debt and because of the sum she had just paid to the settlement company. She lost everything, all $8,000. She's now homeless and intermittently lives out of her car with her disabled husband and 2 children. And still, she owes that $15,000 in medical debt.
Thank you, Ms. Bowers.
I actually had one more question. I just had to move my page. One more comment. Can I just finish up real quick?
Sure.
And finally, we hear from people across the state that they are harassed and trapped by debt collectors, including on time-barred debt. This year, this coming legislative session starting in January, we will make consumer protections for debt collection and debt buying a priority in our state legislative session. While we're fighting on a state level, we are urging you to help us by enacting strong policies around debt collection practices at the federal level that will help people keep more of their hard-earned income and give them a way out of debt rather than creating more debt for them. Thank you.
Thank you. Mr. Brian Moore.
Hi, my name is Brian Moore. I'm an executive director and industry practice leader at Veroli Corporation, a Seattle-based company that provides a platform for companies to interact with their customers through electronic digital means. We've heard a lot today about how our courts are being clogged by debt collections lawsuits. There's another type of lawsuit that is also clogging our courts, and it has to do with enforcement of the FDCPA and another federal law, the Telephone Consumer Protection Act, the TCPA. Both of these laws need to be updated, modernized to reflect the current state of technology. Most recent CDC survey, it's called the National Health Interview Survey, found that 34% of Americans are mobile only. In other words, the only type of telephone communication they possess is a mobile phone. However, the Telephone Consumer Protection Act, the TCPA, has a sort of interesting provision within it that makes it difficult for companies to communicate with their customers on their mobile phone in a legal and efficient manner. Lawsuits are being brought against these companies for technical violations of this act when in fact the communication was desired by consumers, such things as potential fraud notifications on their credit card, flight delay notifications by airlines, and in fact past due account notifications by creditors. So I urge the Bureau and our elected representatives to look at these acts and the need for their update and modernization to reflect the current state of our society. Thank you.
Thank you, Mr. Moore. Julia Kellison.
Thank you for allowing us this opportunity for public input. My name is Julia Kellison. I'm a staff attorney at Northwest Justice Project. Northwest Justice Project, or NJP, is a civil legal services organization that serves thousands of low-income people each year from 13 offices across the state and through our statewide intake line. I practice out of NJP's King County office here in Seattle, and about a year and a half ago, we started a debt collection defense clinic patterned much on our legal aid colleagues in New York and Chicago. We started here in Seattle to help people respond to debt collection lawsuits. We started because we knew thousands of people a year were facing debt collection lawsuits without representation. It did not take long for us to see the patterns of bad debt collection practices. Each week, we assist low-wage workers who are hanging on by their fingernails financially, trying to lift themselves out of poverty and working at jobs at which they're being garnished for debts that they don't owe or have been inflated exorbitantly by collection fees and costs tacked on by debt collectors. Many of these people tell us that before the lawsuit was filed, debt collectors refused to enter into reasonable payment plans and instead demanded lump sum payments of thousands of dollars. We are seeing an explosion of lawsuits brought by debt buyers who further harm consumers' credit by suing them for old debt the company bought on the market for pennies on the dollar, as we've heard, and that they can't prove because their evidence is horribly deficient. We see people victimized by debt settlement companies that promise to help consumers negotiate down their debt, but that in reality just take their money and leave the consumer exposed to lawsuits from those creditors. We see people pushed to the brink of bankruptcy or wrongfully garnished for medical debt that they don't owe. Consumers eligible for charity care don't know about the program because some hospitals are not publicizing this program adequately to people in need. Once that debt goes to collections and the consumer gets sued, it can be very difficult for the unrepresented consumer to enforce their right to suspend the lawsuit and to be considered for charity care assistance on the underlying debt.
Thank you, Ms. Kellison.
I have one more quick point. We see seniors in tears because of the stress that debt collectors place on them to pay debt, even though their low fixed income is exempt from garnishment. The power imbalance, the corporate debt collection industry, and stressed out low-income consumers is apparent every day in our country's court system. We're pleased that the CFPB will be working to help curb illegal debt collection practices. Thank you.
Gina McNaughton.
Thank you, and I wanted to thank you for this opportunity to speak. My name is Gina McNaughton. I'm a subject matter expert in debt collection, also a partner at the McNaughton Group. And I'm actually a neutral party. I grew up at the world's largest collection agency for over 16 years. Currently, I have a consulting firm. I feel like I have my back to you. I'm not sure who to turn to. Currently, I have a consulting firm, and I actually audit collection agencies. I just had a statement, not really a question. And the first statement is about the FDCPA. This is not something that we're hearing for the first time. This question has been out there for a very long time, and it's something that really, hopefully, will be addressed at this meeting. And when you take this information back, that it's something that we can really get to the bottom of, and instead of talking about the subject over and over, that we can actually start to put that process in place. And having the ACA here and also members of the California Association of Collectors, I would hope that those meetings could get off the ground and start to work forward with updating the FDCPA. And also, I also wanted to talk about standardizing of templates. As a person that actually audits collection agencies, one of the things I have a problem with is, unless you're in this business, you would understand that there are several different platforms that collection agencies are using, which makes data different at different locations. So if one suggestion I would make is that you start to work on some type of a standardized template, not only for the placement of accounts, so that we're all on the same page, but also for the legal process. If you were to put that system in place, I think we could reduce a good amount of the complaints. Thank you for this opportunity.
Thank you, Ms. Naughton. Scott Kinkley.
Thank you. I'm Scott Kinkley. I'm a lawyer in private practice on the other side of the state in Spokane, Washington. And our courts, like I assume most of the courts around this country, are just overburdened with the collection lawsuits that are coming in. And we've had a unique program there that I wanted to share with you folks at the CFPB. The way that our court treats the collection lawsuits is not like any other regular lawsuit. They bundle them all together, and they don't assign them to a judge. And I think it's the same way around the country. They have a collection docket once a week where all the summary judgments are heard. And what we did in Spokane County, with the blessing of our judges and our Spokane County Bar Association, is created a volunteer lawyer program where a number of us go and we sit in the back of the courtroom during the collection docket, and the judge will announce to all of the pro ses who've showed up that day, which is often maybe one of 12 on the docket, sometimes none. And the judge will give us the opportunity to meet with them, review the file out in the hallway for 5 minutes or 10 minutes, and then come back into the courtroom and argue the case for them. And what I wanted to share is, in the over 1 year that we've had this program, we've only lost 2 cases. And the way that we are winning is we are looking at the evidence that is actually being brought to court by the collection agencies and the debt buyers. We're looking at the credit card statements that are dated later, or have, like was pointed out, addresses that shouldn't be there for the date that's on the statement, credit card contracts that post-date the debt, amounts that don't match from the complaint to the affidavit, irregularities in the affidavit. We have seen things with robo-signers and other things like that, but other than that, there are also other irregularities. We point these out to the judge in just 5 minutes of combing through the file, and in the hundreds of cases that we've appeared on, only 2 judgments have been entered. And I think both of those were entered incorrectly, but of course I would. But it just speaks to the lack of quality and the lack of credibility in the evidence that is being manufactured for these lawsuits. And it's the same stuff in my county that it is in every county in the state and every county in every other state. And I would urge the CFPB to take a hard look at the creation of these documents, where they're coming from, how they're being generated, and I'm not sure what you do about it, but look closely at it and put an end to this practice. Because if they're bringing hundreds of lawsuits that we're appearing on and only 2 judgments get entered, what about the other 1,000 people who don't show up to court that day or are not in our county? And
thank you,
thank
Mr.
you for your
Kinkley.
consideration.
What court was that in Spokane? Is that a small claims court, or is that a common police court?
Andrew Schaefer. Judy Paston.
Poston. Hi, good morning. My name is Judy Poston, and I am the program coordinator for Solid Grounds Financial Fitness Boot Camp here in Seattle, Washington. In my role at work, I work with many folks who have medical debt or credit card debt resulting from loss of job, being underemployed, victim of domestic violence, death of a family member, etc. Many of these folks wish to be in a position of having enough income to repay their debt. Some folks in good faith have negotiated repayment plans with a debt settlement company, only to later find that of the thousands of dollars that they paid to the debt company, only a small percentage of the dollars went to the actual debt. These predatory tactics used by debt settlement companies send already financially struggling folks further into debt, which can lead to emotional and physical health issues, thoughts of suicide, as well as homelessness, and further negatively impacts their credit history. It is really expensive to be poor, and there should be legal protection for people who get caught in the trap of predatory and unfair debt collection tactics. I want to share a quick true life story about one of my clients who went to a debt settlement company to have them negotiate lower interest rates and compile her entire debt, the debt that she had that was in collections and debt that was not in collections. After she paid the company the startup fee plus went into agreement with them, they contacted the collection company, made arrangements, and they came up with this huge monthly fee for her to begin repaying, which she did. Much later, she found out that of all the thousands of dollars that she had paid, none had went to the companies to repay any of her old debt. So this was a client who, in all good faith, wanted to repay all of her debt. So then she had to consider the option of filing bankruptcy. I thank you for listening, and I thank you for working to change laws to protect already financially struggling individuals and families.
Thank you, Ms. Poston. Charlie Helms.
Yeah, hi, I'm Charlie Helms. I'm Director of National Affairs for Apprizent. It's a nonprofit housing and financial counseling agency. And we get about 60,000 calls a year from people in distress, people in financial distress. And a lot of them now have been for getting onto time-barred debt and ghosting of accounts. People are getting called after they moved 3 or 4 times with new jobs to different states and are really getting hounded and harassed by collectors. That's something that we're really seeing a lot of, and I appreciate the CFPB taking time to find out about this, and maybe under the CFPB's guidance we could get clear and transparent rules for the collectors so that this can't be done. It's a cause of great emotional distress, and I'm just backing everything that the consumer affairs folks have said and the other testimony. Thanks for doing this, and we really hope something happens to help our clients. Thank you.
Thank you, Mr. Helms. Oscar Eason Jr.
Thank you very much. My name is Oscar Eason Jr., and I'm president of the Alaska, Oregon, and Washington State Area Conference of the National Association for the Advancement of Colored People. And I want to thank you very much for holding this hearing today, and mainly because a great impact, I think a serious impact has prevailed over the community of people of color during the 08-09 downturn. And the impact itself has been tremendous in this regards. We've just been told that there are 4,000 collecting agencies that are in business collecting debt. Of that 4,000, I would imagine, well, the question I would ask is how many of the 4,000 who just went into business during the 07-08 downturn? Some of the practices that were described by the panel are really not being adhered to. I can tell you quite frankly that when a collector calls, and this of course is a common problem with our members and some of the people across the country, when a collector calls, you have to assume, first of all, that a debt collector is trying to collect a debt. I mean, otherwise, if you think otherwise, you'd be dumb or completely out of contact with reality. But one of the practices of the debt collector, remember, is that the first thing they do is they leave their name and their first name, and they'll leave an extension. You don't understand. You don't know who the company is. They don't give you that information. You don't know what company is they're working for. Number two, they don't only call you to collect the debt, as was indicated here, they call also to get information on who may be the person who might be the real debtor. And of course, God help you if you've got a suffix. If your name is Junior, or if your name is the fourth, or if you are senior. And one of the things that might arise during that conversation, it may be repeated over and over. If you are not the person, they want the name of the true person. And generally, if you know the name of a relative who might have the very same name, you'd be very reluctant to, if you otherwise have a sane sense of relationship, family relationship, you'd want to know, you would be very reluctant to call that name. The other thing I'd like to mention is the fact that the credit report companies, I think there are about 3 major references that is commonly used by these credit report companies. That information sometimes is not very good information, and the person on the other end of the line wind up saying, well, that's not me, that's not me. And I tell you, I've had the experience of being called by my own credit union. And they said, well, we're going to give you 3 questions. And I can tell you quite frankly, none of the questions applied to me. They all applied, of course, to my son, who happens to be Oscar Eason IV. But those are some of the common things that do occur during these conversations with the collecting agencies. And the NAACP is on the forefront of this. We'd certainly want whatever that is being done at the federal level on this, we certainly appreciate what is being done, and we'd ask to have a little more done, just so that our people can enjoy life a little better.
Thank you, Mr. Easton Jr. Mike Kinkley.
Good afternoon. I'm an attorney in private practice in Spokane, Washington. I've successfully brought dozens of class actions against debt collectors. When you hear the debt collection industry talk about modernization of the FDCPA, what they're talking about is the ability to contact you by your cell phone. They're talking about harassing you in your electronic neighborhood by getting into your social media. They're talking about leaving messages because they have a problem under the law as how they're leaving messages. And they're talking about contacting employer and third parties. That's the modernization they want, but that's a political problem. Quick point there. The CFU folks can do something for me that I can't do. The debt buying industry has a really odd model that nobody seems to know about. Through discovery, we've deposed many of the robo-signers, the 400 to 600 a day. We've been involved in the Visal case that you guys, at least through the FTC, spoke out about. The banks, because they have to charge off the debt, sell the debt to the debt buyers, the $1 billion per year companies that you're now starting to look at. But the banks finance those sales. Then the banks, of course, then the debt buyers securitize and break up, just like they did in the mortgage industry, the debt itself, or they put it in securitized trusts. Well, the banks are the investors, the very banks that sold the debt, financed the sale of the debt, are now securitizing and making profit from the collection of that same debt. Now, I can't afford to take the depositions and hire the experts to figure out why that's a tax benefit, why that's an accounting boon to them. I don't know what they're doing and why they're doing it, but it's part of the corruption of the system. And I think it was in 2009 that the FTC, I was on a panel in San Francisco, that ultimately the FTC came out with the very nice paper that a broken system, debt collection. I'm sure you're all familiar with it. It's still broken in the same way because it's a systemic problem. The problem is this: there is no such thing under the law as a cause of action for a collection action. It is not. It's a contract action. And a contract action has discrete elements of proof that have to be made. The problem is when people buy debt in the volume they buy it for the price that they buy it, they don't and can't afford to buy the proper documentation, and often at times it doesn't exist. So they have a hole in their case. They have a proof hole of the existence of the terms and conditions of the contract and the proof of the interest rates, as you guys have shown recently with the $200 million against Discover Bank and others, unlawful charges. They have a huge hole in the presentation of that case to the court. So how do they fill that hole? They fill that hole with fraud. They have people sign affidavits who don't have personal knowledge. They have documents that aren't attached by the affiant. It's a complete fraud on the courts, and the courts haven't known this, and the judges still are having trouble accepting this fact. The fact is that each and every one of these contract cases, not collection cases, that's a nice term we use to say collection cases to talk about this area, but it's fact a contract case. They lack the proof because their proof is hearsay, unless it's the exception, which is the business records. It's all documentary proof, which it starts out as hearsay, unless it's an exception. So they try to pretend it's an exception to hearsay with this false affidavit. And that's our problem that has to be addressed and can't be fixed by us case by case.
Steve Bro. Matt Marstad. Okay, that concludes the field hearing in Seattle, Washington today. Thank you all for attending, and thank you to all those who watched live stream.